Get ready. 3, 2, 1, start. The learned senior counsel appearing for the petitioner would submit that the spirit of Rule 4.3 of the Foreign Exchange Management Adjudication Proceedings and Appeal Rules 2000 has not been adhered to, and therefore subsequent proceedings are to be held as null and void. In the event of communicating the reasons recorded for proceedings with the action, the petitioner would be in a position to defend their cases, and therefore the importance of Rule 4.3 of the rules is to be considered by this court. The learned senior counsel would mainly contend that the issues pertaining to Rule 4.3 of the rules are well enumerated by the Bombay High Court in the case of Shashank Venkatesh Manohar versus Union of India, reported in 2014, 1 Maharashtra Law Journal 838. The said judgment has been confirmed by the Supreme Court in SLP, and consequently Enforcement Directorate issued circular of the year 2014 cogent reading of the judgment and the circular would reveal that are no more res integra and to be followed scrupulously while taking a decision to proceed with the inquiry under Rule 4 of the rules. The distinction has been drawn with reference to the judgment of the Bombay High Court and the Division Bench of the Madras High Court in the case of India Cements Limited versus Union of India, reported in CDJ in 2018 MHC 3298. In this context, the judgment of the learned single judge of this court in the case of Ramakrishna Setu versus the Special Director, Directorate of Enforcement, reported in CDJ 2014 MHC 3886, has been referred, wherein the learned single judge considered the interpretation offered by the Bombay High Court on Rule 4.3 of the rules. The learned single judge has made a finding that the interpretation given by the Honorable Division Bench of the Bombay High Court to the expression as opinion appears to be very elastic. The learned counsel for the respondent would submit that the circular issued by the department in implementation of the Bombay High Court judgment cannot be relied upon. The departmental circulars are not binding on the persons or quasi judicial authorities or courts, and therefore, in that view of the matter, the circulars issued by the board would not assist them. Circulars and instructions issued by the board are no doubt binding in law on the authorities under the respective statutes, but when the Supreme Court or the High Court declares the law on the question arising for consideration, it would not be appropriate for the court to direct that the circular should be given effect to and not the view expressed in a decision of this court or the high court so far as the clarifications issued by the central government and of the state government are concerned. They represent merely their understanding of the statutory provisions. They are not binding upon the court. It is for the court to declare what the particular provisions of statute says, and it is not for the executive. Stop.